meeting of the Scottish Affairs Committee. We're delighted to have Dorothy Bain Casey, the Lord Advocate, with us today, and Jenny Hamilton too. And we're going to be looking at questions arising from the Fiscal safer drug consumption space in Glasgow. The committee has visited the Thistle and has already taken some evidence on the operation, and we've also visited the safer drug consumption spaces in both Oslo and Bergen. So we're very interested to hear what you have to tell us today. So I wondered if I could kick off by asking what legal risks are associated with the operation of the Thistle, and in what ways your statement of prosecution policy addresses them, Lord Advocate.
Well, I suppose it's helpful just to start off by explaining broadly what a statement of prosecution policy is. It is an instruction to prosecutors as to the public interest in taking a particular response in a particular context. It is a statement of the way that the public interest considerations relevant to a specifically prosecutorial decision, which are generally identified by the Scottish Prosecution Code, would fall to be applied by prosecutors in a particular context. In this context, is a statement that it would not be in the public interest to prosecuting users of the Glasgow Safer Drug Consumption Facility for possession of drugs for personal use. In terms of legal risks for the facility itself, I was not asked to sign off on how the facility itself was operated, and it wouldn't be appropriate for me to do so. And so any statement of prosecution policy should not be construed as a ban on prosecution of offences under the Misuse of Drugs Act 1971. And it shouldn't be construed as prosecutors not enforcing the law. And it doesn't represent an immunity from prosecution provided in advance. So that is the statement of prosecution policy. That is broadly what it is, and probably broadly what it applies to. In terms of the legal risks for the operators of the facility, that is those operating the facility to consider and guard against in terms of their standing operating procedures.
So would you expect those operating at the City Council and the Health Board, etc., to have regard to your prosecution statement and to measure their activity against that, in effect?
So I suppose it's important to know what the statement of prosecution policy covers and why it's needed, and then think about how that impacts on those operating the safer consumption facility. So the statement covers simple possession offences under Section 5.2 of the Misuse of Drugs Act 1971. It only applies where the controlled substance is intended for personal consumption, that is not drug dealing or possession with intent to supply. And it only applies to cases where the controlled substance is recovered within the boundaries of the facility. And it only applies when the person is attending the facility. It wouldn't cover, for example, medical professionals working there who are found in possession of drugs, or indeed are committing any other offence under the Misuse of Drugs Act, or indeed any other offence. The prosecution policy only covers the duration of the pilot, and it doesn't cover offences detected outside of the facility or on the way to the facility, and these are dealt with in the normal course. So for those who are operating the facility, they obviously are seeking to engender a confidence in the users coming forward to the facility in order that they can be provided with this safe space, hygienic, supportive space to administer drugs if that's what they wish to do, but also to engender confidence in seeking the other available resources within the centre that would direct those vulnerable individuals to support mechanisms, support systems, and indeed safe spaces, hygienic spaces, washing facilities and the like. So I suppose for those operating the facility, all they need to do is to ensure that they operate it within the law, within the standing operating procedures that they've set down, and they recognise that for those who are coming with possession of drugs, that they are, on the face of it, breaching the law, but there is a prosecution policy in place that means these individuals won't face prosecution, they won't be brought before the courts, and it's hoped that this combination of the statement alongside the way that the facility operates delivers ultimately what the aim of the facility is for, which is to reduce public drug use, reduce drug deaths, and hopefully identify a route for vulnerable people to gain help and support that they require.
That's helpful, thank you. I'm going to pass to Harriet Cross.
Thank you, and good morning. Thank you for coming in. I think we've touched on it a bit there, but I think I'd quite like to explore a bit further sort of the reasons why possession is the only offence covered by the prosecution policy. Is there a reason why this is the only one, and is there any scope or reason that you could see that this may or may not be extended to other offences, and what would the impact of this potentially be?
So I think it's important to understand the law are in around and the constraints in around the Lord Advocate's prosecution policy and the statements involved in that. A statement of prosecution policy requires to be carefully defined, publicly stated, and capable of being enforced without any form of difficulty. And to be lawful, it has to meet these necessary standards of a policy that's clear, readily understood and publicly available. A wide-ranging statement that would relate to a number of offences that might or might not be committed within the facility by those who are working there and those who are attending there, such as being concerned in the supply of drugs or assisting in administering drugs. That's far too wide a ranging concept for a statement of public prosecution policy to be made. It wouldn't be lawful. And the law requires the statement is very focused and easily understood. There are numerous examples over the history of Lord Advocates' statements in these matters that we can provide examples to you for in relation to, for example, where an individual was in a persistent vegetative state and the doctors had identified that they wouldn't be resuscitated in certain circumstances. There's statements of public prosecution policy in and around the provision of safe needles and in relation to the use of naloxone, but it would just not have been lawful to provide a wide-ranging statement that wasn't readily understood. So why is it needed in this case? Why is the prosecution policy needed in this case? And what I understand is that the proposers, in relation to the facility, took legal advice and are content that they could operate within the current legal framework, except insofar as the users of the facility would be in possession of controlled substances. In normal course, if an individual is reported for simple possession offences, a range of options, including prosecution, is open to prosecutors. And for individual reported simple possession offences, I would expect prosecutors to consider the potential use of diversion from prosecution for very vulnerable individuals. They may also consider offering a fine, and indeed some cases, and of course prosecution may be a possibility. So this provides reassurance to those attending the facility that they will not come into the criminal justice process, which we know seriously upends an individual's life. They will not be fined, and there's no potential for prosecution. And the statement therefore puts a particular prosecutorial response to possession of drug offences in this specific context beyond doubt, providing what I hope is the confidence to those seeking the support of the facility that they can do so without the risk of prosecution.
Okay, thank you. I understand what you're saying. I think the difficulty is that possession is one thing, but obviously there's a huge number of other areas within drug policy or within public prosecution policy in which drug offences fall. They're not just possession. There are a wide range of things, many of which you've touched on already. Where does the balance lie between what happens within a facility and what happens out with a facility? And how can we ensure that people working in the facility, people using the facility, people on the outside looking at the facility and what's actually happening there, how can they have assurance and reassurance that we are not effectively, to an extent that we are, but we're not advocating any more relaxation of drug policy or anything that comes from that? We've talked about possession, but things, for example, that happen because of the use of drugs. So, for example, we know that it leads to higher murder rates, manslaughter rates, public disturbances. How do these get separated from actually removing the prosecutorial element of the possession to actually other elements of drug taking and the impacts of that has on the community, which may happen out with the facility, but as a result of the drugs being taken?
Yeah, so it's a question that I think probably should be directed to those who operate the facility, because the standard operating procedures and the reassurances that I was given by those operating facility was that they could operate the facility within the law, and the only challenge that presented was that in relation to the individuals presenting with drugs and requiring the support to administer these in the safer facility. So the question of other areas of criminality, indeed within the facility or without, these remain subject to the same sort of prosecutorial decisions, the same sort of police response that one would expect in any other circumstance. So I think it's really important to understand the key difference between what was originally asked of the previous Lord Advocate and what is being asked now. Because the scheme that the then Lord Advocate was previously asked to consider by the Glasgow Health and Social Care Partnership was one in which he was asked to give a blanket immunity for all criminal offences. And that simply couldn't be done, because, as you rightly identify, the risks associated with drug use means that there is a risk of further offending, including, sadly, as we know, circumstances where individuals are exposed to the criminal prosecution for culpable homicide. But so the wide-ranging request and the fact that there's a whole gamut of offences that could be committed, simply it wouldn't have been capable of being met by a limited and targeted statement of prosecution policy. And that's all that has been given here. A limited, targeted statement of prosecution policy for a pilot that will be re-evaluated in accordance with the work that's been done by those operating the facility. It's simply not open, and it's not lawful for a Lord Advocate to issue a wide-ranging immunity from prosecution in advance of the conduct taking place.
I understand. So on that, so if in the course of the facility proceeding, and if you were not satisfied that the operating procedures there were sufficient enough to replace the legal framework, which effectively was being happened for possession, would you see that as a case or a cause to revoke or change the prosecution policy that's been put in place?
Well, the statement of prosecution policy is heavily influenced by what is in the public interest. And I identified that we could apply this policy because it was limited and readily identifiable in the context of the drugs crisis that faces Scotland. It was also the fact that I was provided with detail about the way in which the facility would operate. I was provided with affirmation about community engagement, and my officials worked very closely with Police Scotland, and the police were able to confirm that they would be able to police the facility. And these combination of factors permitted the very limited statement of prosecution policy to be made. Now, if the public interest was to be re-evaluated, which it will be, and there is evidence base for saying the standard operating procedures that assured us that the facility could operate within the law, except in relation to the possession offences. If that demonstrably wasn't the case, that would be a factor that quite rightly would be taken into account in reaffirming the statement of prosecution policy. So that it's got to work, and we've got to be satisfied that it's working, and it's not causing difficulties, it's not raising the risk of further criminality, and it's not having an unlawful impact on the community and the health of those who work in the facility and outside. So that would be a factor that would be taken into account on any revision of the policy.
Thank you. And finally, just really quick one. We know that the UK government has highlighted certain areas that it is concerned of in terms of the operation/prosecution policy. Are there legal gaps that remain, and what is the approach to sort of tackle these, or are you pretty confident with how things stand at the moment?
So, in relation to how the facility operates and how the standing operating procedures are upheld, and the fact that we've been assured that the facility can operate within the law other than in relation to possession offences, that's all that I am concerned with at this stage. If there is to be wider statutory policy changes to allow the facility to operate beyond the pilot, then that would be a matter for the elected parliamentarians to consider. I'm a law officer. I'm not a politician. I'm not a member of any political party. And if there's to be changes in legislation to permit the facility to operate in a different way, with a different legislative framework, that's not for me. That is for you, the elected parliamentarians, to consider and to debate and to take on advice from those who are working in this very challenging and important field.
Thank you.
Pastor Jack Rankin now.
Thank you, Madam Chairman. Thank you for coming, Lord Advocate. I just want to dig into some of the answer there that you gave to my honourable friend, the member for Gordon and Buchan. You're quite clear that you see this slightly differently from 2017 in a movement that previously asked for some kind of blanket immunity where you think this is much more limited. But the Home Office has said that, and I quote, "There is no lawful basis by which drug consumption rooms can be operated in the United Kingdom." And when refusing to grant this application in 2017, your predecessor didn't necessarily talk about, to my understanding, the scope of it, but rather he talked about the principle, claiming the matter was one that should be dealt with by Parliament rather than the Lord Advocate. So, on what basis do you think that this is a matter appropriate to address through prosecutorial discretion, not one for us in this place, as you say?
Well, I hope that you have read the written evidence that was presented and appreciate the constitutional position of the Lord Advocate of Scotland, which is different and distinct to the way in which the prosecution operates within other parts of the United Kingdom. And the drivers for agreeing to this request were that I was asked a specific and focused question about the public interest in prosecuting individuals using a specific type of facility. I'm not in a place to comment on what the Home Office has said or what other areas of the United Kingdom might provide for. I was operating as the Lord Advocate in the constitutional position that I hold, and one that I protect fiercely. The relevant considerations for me in granting this specific and focused prosecution policy statement were that the facility would operate in a place where public injecting in Glasgow was already a significant issue, and I know that you've heard a lot of expert evidence about that and the profound concerns of those who work in the field dealing with a very challenging situation that is faced in Scotland. And I understood also that it was intended to engage with those in that area whom health and support services find very difficult to reach. So central to my consideration as the Lord Advocate of the request was the fact that the proposed facility would be co-located with other services which, taken together, may be able to offer a range of care, support and assistance to those consuming drugs. And further, although I'm aware it's not the main aim of the proposed facility, my understanding and the apparent reality is that the facility could cover, over time and in some cases, the necessary resources to assist vulnerable individuals into recovery. I was assured that the local community would be proactively engaged with and the impact of the facility carefully monitored, and that the police, Scottish Police, would be capable of effectively policing the facility. And I was also assured that the pilot and that its impacts and effects would be subject to a highly rigorous evaluation. And moreover, in addition, the co-location with other services and the potential for assistance meant that the statement of prosecution policy is in keeping with the long-standing principles that underpin the Scottish approach to diversion from prosecution. We seek to uphold a prosecution service that's progressive, humane, and provides justice and delivers mercy also, as though we have a diversion policy that allows prosecutors to make an offer of a referral to local authorities where there's an identifiable need which has contributed to the offending, which can be best met through a diversion scheme. And I have said previously that the addiction to drugs may be such a need, and in these particular circumstances, I am content that the proposed facility could provide a mechanism to engage with some of the most vulnerable people in our society. We're not changing the law. The law remains. It's just a statement that those in possession of drugs looking for help aren't going to be prosecuted. I've not changed the law.
Thank the Lord Advocate for her answer, and this is maybe more of a comment for me than a question back to the Lord Advocate. You make an incredibly compelling case that this facility is in the public interest. I acknowledge I'm not a lawyer, I'm a layman and a new parliamentarian, but the case you articulated to me sounds very much like one that should be in the realms of policy rather than the law. That's not a challenge to you. That just seems to me as a layman where this really should sit most appropriately.
I think that I respect entirely your point of view, and I congratulate you on your election. It must be a very wonderful experience for you to have the privilege of serving on this committee that's dealing with such a highly important matter and of enormous public interest in Scotland. I do ask you to think about the constitutional position of the Lord Advocate in Scotland that's been in place since the 1500s and has served Scotland well over that time. And after today, I can share with you the historical context of the great office of state that I hold and the detail of the dual role that I operate. And certainly you will be hearing, I think soon, from the Cabinet Secretary for Justice in respect of whom policy considerations and the development of the law in and around these issues in Scotland lie.
Okay, thank you.
Kirstine Sullivan has a supplementary question to that.
Thank you. Just a very brief supplementary, Lord Advocate. Just picking up on the last question from what you said earlier this morning, am I correct in understanding that the proposal put to the previous Lord Advocate was substantially different to that which was put to you, perhaps on the basis of a better understanding of what the law required in terms of a statement of prosecution, which would allow a more targeted facility and allow you to provide a statement that is clear, understood and readily available to the public. Is that the difference?
That's exactly right. You have it absolutely. And I think we can draw an analogy with the statement of public prosecution that the Lord Advocate of the Day in Scotland issued in relation to those seeking to be assisted in suicide. There was a case called Ross that went to the Appeal Court in Scotland, in which it defined the parameters of a statement of public prosecution policy in Scotland, and that's something we can share with you after today. But why the former Lord Advocate rejected the previous proposal? As I understand it, the then Lord Advocate was asked by the Glasgow City Health and Social Partnership to confirm, by way of guidelines, letters of comfort, protocols, or indeed a form of policy, that a wide range of persons, the Health Board, the Council, their staff, the partner organisations and their staff, and service users of a proposed drug consumption facility would not be prosecuted for a range of potential offences. The proposal involved a request for immunity from prosecution for a wide range of offences committed by both users, operators and staff, up to and including the very serious offence of culpable homicide. There was also a request to the Lord Advocate to permit a tolerance by police officers of those found in possession of drugs claiming to be on the way to the facility. And though then the Lord Advocate recognised the serious public health concern motivating the proposal, it simply wasn't open to the Lord Advocate to grant such a wide-ranging immunity. And it's just, I suppose, what was eventually asked was a different question. What is in the public interest?
Thank you. Elaine Stewart now has a question.
Thank you and good morning, Lord Advocate.
Good morning.
The Statement of Prosecution Policy provides a radical change in the UK's approach to drug treatment. To what extent is it ideal for the radical change to be enabled through prosecutorial discretion rather than a full legal framework?
Well, it always has been the case that the Lord Advocate in Scotland can make statements of prosecution policy. And in this context, and in every other context in which prosecutors in Scotland take decisions in and around prosecution, we consider the public interest. And the public interest is set down, how the public interest is considered is set down in the Scottish Prosecution Code. This isn't anything new. We have numerous examples over a long time of statements of prosecution policy. For example, the provision of safe needles and the administration of naloxone. So this isn't new, but the question is, what is the position in Scotland and what does the public interest require? We've seen from the expert evidence that this committee has heard that Scotland has a particular problem, and it's driven by a lot of factors, some of which relate to post-industrialisation challenges, deep-rooted areas of deprivation that expose communities to the risk of drug use, that then expose those within those communities to the risk of drug deaths. Now, as the public prosecutor responsible and the head of the system of prosecutions in Scotland, I am asked the question in every decision I take, what is in the public interest? Is it in the public interest to prosecute individuals within the safer consumption facility for possession of drugs, where part of the reason that we understand that they go there is to seek help, seek safety, seek hygiene, but also seek the opportunity to be referred to other support services? What would be the point in setting up such a facility if the individual going in there is going to be prosecuted? Why would they go? It makes no sense. And so it's a very simple concept. What is in the public interest?
Thank you. That was a nice full answer. Thanks very much. Made me understand that a bit better.
Back to Kirstine Sullivan again.
Thank you. Lord Advocate, you mentioned some of the aims of the facility insofar as reducing public drug use, reducing drug deaths and helping vulnerable people to access support to recovery. To what extent was your prosecution policy predicated on academic and medical evidence that drug consumption facilities benefit public health?
So before the decision was taken, ultimately by me, as Lord Advocate, head of the systems of prosecution, there was a significant body of work done by the Jenny and her team within policy, and by those responsible for the operating of the facility, and by the police in around whether or not this was a good idea, to put it simply. And fundamental to the decision making is what the expert evidence base reveals. And there are arguments in around all of that, for and against, that we've read, but there was a significant body of evidence from international bodies, from those advising on the challenges internationally and nationally of what it means to have a drug problem such as we had in Scotland, of whether or not the safer consumption facility would be one aspect of an appropriate response to what was a very challenging problem. And so within all of the material that we looked at, certainly the officials within Crown Office looked at the evidence base for the assertion that the safer consumption facility was something that could assist in the possible reduction of drug deaths, but also assist in the reduction of public consumption of drugs, public injection, bloodborne viruses, disease associated with drug use. So we looked at expert evidence, nationally, internationally. We looked at experts in the field, and we were heavily influenced by what the medical profession within Scotland and were telling us. And I think that there was an overwhelming body of evidence that said to us that there was a sound basis to say this could help, and it would be in the public interest to have a facility of the type envisaged, and to have a pilot to see if it does work, to allow for a better evidence base for further prosecutorial decisions by perhaps later Lord Advocates, because I recognise I'm only the custodian of this office for a short time in its great history.
Thank you. So, as the Chair mentioned earlier, this committee has visited sites in Oslo and Bergen. Did you and your office look at evidence from such sites, particularly where there are comparative or where comparative problems in terms of not just drug deaths but drug harms, including those arising from bloodborne conditions?
So, lawyers working on behalf within the Crown Office, I'm not sure, have you visited abroad? I don't think so, no. But certainly they were aware of there's quite a substantial body of evidence published, and so they were informed by that, and they were informed by the experts in the field in Scotland who were saying that they could operate this facility within the law in accordance with their standing operating procedures, and that they hoped that it would assist. And then lawyers working on my behalf did go to the Fiscal Centre before it opened, and were greatly impressed by the facility and its staff. And my involvement in the facility has been narrow and focused on consideration of the provision of a public statement of prosecution policy. And that has provided a framework for the police and prosecutors to deal with cases of drug possession within the facility, and has provided the operators and the users of the facility with the comfort to operate. So in addition, my officials maintain regular contact with the operators, the police, stakeholder groups engaged in the delivery of the facility. I mean, I'm not asked to sign off, in a sense, on the facility. That's not my responsibility. And I don't consider that Lord Advocate, that I personally require to see the operational details of the facility or the practical delivery of the service that it provides. But we have been informed across the board by expert evidence and what seemed to us highly compelling evidence of experts working in the field of medicine in Scotland, that this could help.
Thank you. So that, just to clarify, and I'm aware of time, so if I could just ask you to be brief in this point. You did look at comparative evidence from other cities, countries that had similar problems, and the evidence emerging of the efficacy or otherwise of drug consumption facilities.
Precisely. Before the decision was made, my officials worked on a full briefing to me that looked at the evidence base, but also looked at the law and whether or not it would be lawful for such a statement to be made. So it was a complex analysis that was undertaken, considering expert evidence, factual material, statistics available, and legal analysis. So all of these factors were brought to bear in the decision making that was ultimately arrived at.
So you have emphasised the importance of a robust evaluation at the Fiscal. What outcomes would you class as clear evidence that the facility does indeed benefit public health?
So, it really would have to be a robust evaluation of all that was done within the facility, and that there was, to our satisfaction, a rigorous evaluation that looked at the standard operating procedures, the appropriate risk analysis associated with that, whether or not there was an evidence base to demonstrate that the facility was operating within the law, common law, regulatory law and criminal law, and that those treating the individuals within the facilities were saying as to the outcome in terms of preventing deaths, referral to services, and the ongoing impact on the community in terms of public impact, economic and business impact on the community, and the overall health and well-being of the community within which the facility was located. So it would really be all of the factors that one would expect to be considered during the evaluation process to permit a further assessment to be made of whether or not the prosecution policy that was stated would continue. It would be a robust evaluation exercise looking at all aspects of the facility.
So, just to get a little bit more clarity on this, what outcomes would you see as clear evidence that this facility has delivered benefits to public health? So, for example, reduction in drug deaths and reduction in related illnesses and conditions. I mean, do you have a clear set of outcomes that are in some way will be measured throughout the pilot?
So I think that would be, it is a hypothetical question, and I think we just have to see what the evaluation delivered. But I think that what I did do previously was to explain why it was, the factors that were relied on in order to make the statement of prosecution policy. And if we weren't satisfied in relation to these factors, it would be something that we would have to take into account. But I think you're asking me to comment on something that hasn't yet taken place and hasn't yet reported, and the decision will be made in the usual way, in the public interest, when the evaluation is reported.
I think I'm really just looking for a statement of what you would see the success criteria to be in terms of improvement to benefiting public health as per the stated original intention.
Well, I think that I would have to be guided by the experts in public health as to whether or not they considered it to be a success. I'm not a doctor. I'm not an expert on drug use or drug disease. But what I would do is I'd take into account what the experts were reporting about the impact of the facility. And that's all that the law officers of the day can do. They can't set targets now as to what would be a success, because it has to be informed by the operators of the facility reporting and what the expert evidence reveals.
Okay, thank you. To what extent did your assessment that it would not be in the public interest to prosecute users of the Thistle hinge on the time-limited nature of the 3-year pilot?
So, it was a statement of prosecution policy that relied on assertions and expert evidence and assurances that the operating protocols put in place would meet certain standards and that the facility would operate in a certain way. And it was on that basis that the statement was made. And I think you do have the statement of policy that indicates what was expected, and the fact that it was time limited and it would be subject to an evaluation was important in order to ensure that there remained a lawful basis for the prosecution policy to remain. So it's affording a period of time within which to reflect and determine whether or not the original decision that this was in the public interest remains a sound one.
Thank you. Ms McAllister.
Good morning, Lord Advocate. If the 3-year pilot scheme assessment points towards success, supporting the argument that such a scheme or facility benefits public interest, and as you said earlier to us this morning, it's evidence-based and guided by those experts, can you extend your discretion to allow the facility to continue to operate without a change in UK law? Can you, and would you?
Well, you are absolutely right in the way that you characterised the basis upon which the decision was made. And there will be the rigorous evaluation of the project. And with all of the factors that you've identified, expert evidence, factual evidence, information about the safe management of the facility, if all of it remained compelling as it is at the moment, then whether it's me or another Lord Advocate, the same assessment of the public interest I would expect to be made. But again, it is a hypothetical discussion, and I'm reluctant to be drawn on hypothetical discussions. But if I can say this, that if a request was received for an extension of the statement of policy to extend the pilot scheme, then yes, it would be considered.
It would be considered because your original decision is based on the public interest. So if it remains in the public interest to extend, then the Lord Advocate, if it's you or someone who succeeds you, they can extend, in your opinion. If the UK government expressed opposition to that, and you were in office at that point, would you still do so? And would that influence your decision in any way if there was an expression of opposition by the UK government?
Yes, so again, it's a hypothetical, but I would suppose if the UK government were against the safer drug consumption facility, they would express the reasons for that and why it is the case that, notwithstanding the crisis in Scotland and the fact that it's recognised that a national mission is required to deal with the hugely concerning situation, then if they had something of import and that was persuasive and undermined any argument that was made, then of course that would be taken into account. But I would expect if there's to be a further request for an extension to the pilot scheme, it would be supported by evidence and by appropriate engagement with the police and the local community. And these things just aren't done on a whim.
Appreciate that. Yeah.
it's a very serious issue, and one that is of enormous importance, not just to me, but to the whole of the prosecution service in Scotland, and to our fellow citizens.
Thank you, Lord Advocate.
Okay. Thank you, Lord Advocate. In November 2021, you set out specific criteria that a proposal for such a facility would have to meet for you to be able to consider it, as you have explained to us today. If you were to receive an approach from another local authority or HSCP, which was proposing to have such a facility which also met those requirements, what attitude would you take to that? I realise that's partly hypothetical, but if that were to come to you today, would you consider that?
So, any other proposal of the type that we've got in this case that you've taken evidence on would be considered in the same way.
And is the fact that we're waiting for the evaluation of the Thistle something that would influence your view, that we don't have the outcomes as yet?
Well, the statement of prosecution policy was made in relation to the Thistle on the basis of expert factual evidence and statistical features of drug tests in Scotland. And it was specifically identified in the area in Glasgow that it's operating within because of it was identified that this was a location within which they had particular issues in and around open drug use and the deleterious impact that was having on the local community and the business community, and the fact that there was a focused area within Glasgow where it seemed to be a very intense problem. So all of these features bled into the ultimate decision that was made, and there would be no reason why, if notwithstanding the evaluation hadn't been properly reported on and we hadn't received all of the information resulting from it, there'd be no reason why we couldn't make the same sort of assessment even now in relation to another such facility, so long as it was underpinned by this very strong evidence base that we were given in order to make the decision in relation to the Thistle Centre.
Very helpful to know. And can I ask you, have you received any other such proposals?
I haven't received any other proposals.
Okay, thank you. I'll now pass to Maureen Burke.
Thank you. Welcome, Lord Advocate.
Thank you.
While those within the facility will not be prosecuted for possession of offences, those en route with drugs may be. Yeah. To what extent is this distinction pragmatic?
Well, one of the huge challenges when we were trying to be assured about the basis upon which we were granting this statement of prosecution policy was the way in which the police would be given confidence that they could police such a facility. There was suggestions of exclusion zones and tolerance zones and the like. And that was a very confusing analysis, and it simply wasn't giving the police a clear basis upon which they understood that they were required to do their job, which was to enforce the law. And so the law is to be upheld and enforced appropriately. There is no exclusion zone, there's no tolerance zone, there's no buffer zone. And if the police were to come into contact with an individual who was in possession of drugs for their own use, they would be expected to respond to that in the same way that they would respond even if someone explained that they were on their way to the facility. So there are a number of ways in which the police respond to simple possession offences, from recorded police warnings through to reporting the matter to Procurator Fiscal, who then would take a prosecutorial decision in the public interest in respect of that individual, and a decision would be made whether or not to prosecute. It is unusual for the Crown Office and Procurator Fiscal Service to prosecute an individual for a simple possession offence, and there are diversion schemes that are available in that respect, that we hope we will be able to direct people onto services that provide support and rehabilitation. But I think it is the lawful way within which we can operate the facility.
Thank you. I think you've answered part of the question regarding the inclusion zone. If Glasgow City Health and Social Care Partnership had included a request for an exclusion zone in their application to you, would you have granted it?
No, because there would be significant practical and legal difficulties with such a proposal, not least delineating who it applied to and how broadly. It would cease to be a specific articulation of policy to something much broader. And there is no tolerance zone around the facility. And I think you are to hear from the police later on today. But as you're aware, Police Scotland have operational independence, and it has been of the utmost importance to me to ensure that Police Scotland retain the operation ability to effectively police the facility and ensure that the wider community, those operating the site and those using the facility, can be kept safe. So in practice, if an individual is found in possession of drugs and claims they're on their way to the facility, the officer may deal with the case as they normally would. And as I've said, that may be a recorded police warning or the report to Procurator Fiscal, and the Procurator Fiscal would consider each case on its own individual merits.
Thank you. Thank you for that.
Yes, thank you, Chair, and thank you, Lord Advocate. I think you've been particularly clear about your constitutional position, the remit that you hold, and indeed the rationale behind the decision that you've taken. I think we're all grateful for that. When I visited the facility last Thursday morning, and I'd like to put on record my thanks to the staff at the facility for making that possible at such short notice. There was two issues that they raised with me, which I assume you'll be broadly familiar with. One was in relation to the use of single-use tourniquets, and the other was in relation to an inhalation room. I would be grateful for your views in respect of whether there's any scope for discretion in respect of either of those matters, and indeed whether you've been approached and your office has been approached with respect to either of those issues as well.
Well, I know from reading the evidence and that the committee have heard the need for more facilities to be provided within Fiscal. Inhalation pipes, for example, and inhalation within the facility. And at present, the statement of prosecution policy applies to possession by the users of the facility, and it doesn't distinguish between how the drug is consumed. I've not been asked about the potential for inhalation or asked to develop any policy differently because of the need to assist in the application of tourniquets, and although I would consider each request on its merits, it is primarily for the operators of the facility to ensure that they keep within the confines of the law and importantly, keep their own staff safe. So any request for an extension of the statement to cover potential offences committed by the operators of the facility would have to be considered carefully, and is already the case. I'd expect the proposers and operators to do all they can to satisfy themselves that they can operate within the confines of the law. Personally, I simply wouldn't wish for there to be an incremental widening of the statement of the prosecution policy on the basis that it makes things easier for the proposers. It simply wouldn't be appropriate for me to do that, and for the operators to take shortcuts on the basis that they can simply come to me and ask for an exemption from prosecution from the laws put in place to protect users and staff. So I know the challenges that they face, and the question of what other legal changes are necessary to afford the facility a better way of operating, that's something, again, for the legislator and parliamentarians to consider and legislate on. I can only do what I can within the parameters of my constitutional position and what the law allows me to do.
That's incredibly helpful. Thank you for that clarity. Just on a slightly unrelated note, whilst at the facility on Thursday, I took the opportunity to walk around the surrounding area, as I'm sure many around the table have hopefully done. There was obviously a significant amount of drug paraphernalia in the nearby location. I'm just curious, and we do have the police come and speak with us later on this morning. I'm just curious as to whether your office has received any indication that there's been a rise in criminality or in drug use in the surrounding area out with the facility. There's obviously been a significant number of people who've suggested that's been the case, and I'd be grateful for clarity from you and your office as to whether that reflects the reality that you're seeing.
Yeah, so I can come back on what would happen if the evaluation shows an adverse impact on local community. But I think Jenny does sit on a number of the groups that we have, overseeing what's happening, and in that I think she does gather some information that might be relevant to the point that you've just asked, Jenny.
Yeah, so not being told of a rise in criminality in the area, but Superintendent McEwan, who's attending afterwards, will be able to comment in more detail on that. We are aware, but anecdotally, probably in the same, and indeed through the committee's heard from the proposers themselves, or the operators themselves, about anecdotal rises in drug paraphernalia being left out. My understanding is that that's something that the independent evaluation run by academics, is going to be monitoring. So what I'm hoping is that we'll be able to get that independent view from the academics.
It's very helpful, thank you.
And I think that I would say that if the evaluation shows an adverse impact on the local community, then I would expect the proposers and operators to, at the first instance, respond and mitigate those issues. And clearly, the prosecution policy has a wider impact than on those to whom it directly applies. And any assessment of the public interest in a particular policy or approach must take into account a range of factors, including the impact on the wider community. The impact of the facility on the surrounding residents would be a relevant factor in my assessment of the public interest in issuing the statement of prosecution policy, and it certainly was a heavy feature of one of the areas that I asked the proposers to consider and respond to before we looked at the evidence base for the statement of prosecution policy. And I think we've heard evidence about the community engagement that those who are operating the facility have engaged in.
Christine Sullivan.
Thank you. Lord Advocate, you've touched upon this point already in mentioning the role of members as legislators. To what extent is your prosecutorial discretion an appropriate substitute for a full legal framework allowing and properly regulating safer drug consumption facilities?
Well, the role of the Lord Advocate in Scotland reflects a long-standing history of the office which long predates devolution. I and my predecessors have exercised the functions of the Lord Advocate with professionalism, integrity and independence. And it simply is the position that in Scotland the Lord Advocate holds a great office of state, and the Lord Advocate holds the power to exercise prosecutorial discretion and issue prosecution statements of policy. And the way that I operate my role doesn't undermine the position of the UK government, and it doesn't undermine the law. I'm responsible for upholding the law and upholding the rule of law, and I take the office that I have and the role that I serve very seriously, and I protect the constitutional independence of my role fiercely. And I think that the question that you ask doesn't really fully understand the difference between the systems of prosecution of crime in Scotland and in the rest of the United Kingdom, and the role of the Lord Advocate.
Can I come in on that in the supplementary, Chair?
I'll let Kirsten finish her question.
Sorry, I was just perhaps going to clarify my question more. If there are many proposals being put to you to address an issue of public health, such as the terrible statistics that we are seeing around drug deaths, if you are receiving repeated requests around this, do you see there being it being more appropriate that legislators step in to take ownership of this issue, or do you believe that using the rights and of your office to give prosecutorial discretion, that is an appropriate way to respond to such requests? I'm just trying to understand at which point this really should become a matter of policy and legislation.
Well, I'm only able to operate within the legal framework that exists, and the requests that I may or may not receive will come to learn in due course. As I say, it's hypothetical that I would be asked to make any other statement of prosecutorial policy in relation to any other safer consumption facility. But I can't say any more than I operate within the current law, and if there's to be a change in the law, it's for parliamentarians to make that change, not for me. And I'm a law officer. I'm not a government. I'm not an elected member of Parliament. I'm not a member of any political party, and political decisions taken in relation to the way in which legislation should be changed are ones for elected parliamentarians, and it would be inappropriate for me to express any view on that.
Douglas, did you want to come in on that one?
Please, I appreciate that, Lord Advocate, and this is in no way a criticism of you, but I do feel as if we've had to dance on a pin effectively just to allow one facility to operate. You have quite correctly used your discretion in relation to the statement of prosecution. It's not in the public interest to prosecute, and that allows for this one-off 3-year pilot scheme. If it does prove to be successful and the Scottish Government sees the benefit of rolling this out and continuing with that discretion, obviously the 1971 Misuse of Drugs Act is UK legislation. But I fully appreciate your dual role, and you've explained your dual role to us, that you took that decision as a law officer and that you act independently. However, you are also a minister in Scotland, and you are the principal legal advisor to the Scottish ministers and the Scottish Government. So if they do want to roll out that scheme, what would your advice be to them in relation to how they do that?
I think I can only repeat that the decision for legal change in terms of legislative change is a matter for elected parliamentarians.
But they would take that decision, sorry to interrupt you, Lord Advocate, but they would take that decision, would they not, based on your legal advice, because you're their principal legal advisor and a minister in Scotland?
They would take the decision. Well, I think that it's slightly the question you ask is not entirely relevant, because the decision that relates to whether or not the Misuse of Drugs Act is changed is a decision that rests with the Westminster Parliament. The Misuse of Drugs Act is reserved, and it's not something that the Scottish Government can legislate for. But I think it might be helpful to understand that the position of Scottish law officers reflects a long-standing practice pre-devolution in which members of the government had various responsibilities in relation to legal advice and the legal system and rule of law generally. The Lord Advocate and the Solicitor General for Scotland were ministers in the government, as were the Attorney General and the Solicitor General for England and Wales and the Lord Chancellor. And on devolution, the Lord Advocate and Solicitor General for Scotland became members of the Scottish Government, bringing with them many of their existing functions, including in particular in relation to the provision of legal advice and their independent functions as head of the systems of prosecution of crime and investigation of deaths, and inquiring some new ones, including advice on legislative competence and devolution issues. Other functions, as you know, were transferred to the Advocate General for Scotland. And the law officer's office also became full members of the ministerial team, sharing collective powers with Scottish ministers and subject to the usual rules of collective responsibility. At the same time, special provision was made for providing the appointees with protection against removal and against interference with the exercise of the prosecutorial, investigation and death functions, and the law officers continue to exercise these various roles with professionalism, independence and integrity.
Thank you for that. So when the Scottish ministers decide to weigh up the benefits of the scheme, and you remind them that the Misuse of Drugs Act 1971 is UK based, how far can they take that discussion then in relation to their powers of the Scottish Government to roll out the scheme to other areas across Scotland and to extend the statement on prosecution that it doesn't remain in the public interest to prosecute using those facilities? Because I guess they would turn to you as the principal legal advisor for that advice during those cabinet discussions.
So I think it's important to know that the Scottish law officers are not members of the Scottish Cabinet. They do not have a vote and they do not discuss matters of policy.
I understand that, but they would seek legal advice from you.
I'm just saying, consistent with long-standing practice, the Lord Advocate or the Solicitor General attends Cabinet meetings whenever it's required. In practice, this means when Cabinet is discussing a matter with a legal aspect or to represent their own ministerial interest, in particular the head of systems of criminal prosecution and investigation of deaths in Scotland, the Cabinet doesn't discuss prosecution cases and has never attempted to influence my decision as a prosecutor. I take the decisions as head of the systems of prosecution independently of any other person. My decision on the public interest in relation to prosecutions in particular circumstances will be, and always will be, like all my prosecution decisions, made independently by me. It is a long-standing principle that the law officers operate entirely independently of any other person as they undertake their prosecutorial and investigation of death functions, and as you'll know, this is enshrined in the Scotland Act. It's formally recognised by Section 48(5) of the Scotland Act 1998.
Going back to Kirstine Sullivan.
Just my final question at this time. So you will be aware that some key stakeholders have raised concerns that relying on a statement of prosecution policy allows room for interpretation and discretion, which may result in inconsistent and inequitable application of your policy. How do you respond to that?
I don't accept that. I think perhaps that's unfortunate they think that, and if there are concerns in and around that, that's a matter that could be brought to me as Lord Advocate, and indeed all the officials that I have supporting me, and the work that's been ongoing, and the deep commitment to seeing this is done properly. I'm sure it's unfortunate they feel that way, and we can explain the position if they don't understand it, and that would be an opportunity that I would welcome to be part of. But it's simply an instruction to prosecutors as to the public interest in taking a particular response in a particular context. It's a statement that it wouldn't be in the public interest to prosecute users of the Glasgow Safer Drug Consumption Facility for possession in the facility for personal use. It's as simple as that.
Do you think there is sufficient clarity so there should not be any scope for different interpretations?
I simply don't accept that, and it's of such importance. I think it's deeply unfortunate if that's the point of view that is being expressed, and we would like the opportunity to engage in that, to reassure individuals just exactly what the prosecution statement relates to. It relates to possession of drugs for personal use inside the facility.
Elaine Stewart.
Pleased to know that this is the last question for you today. So what issues would a full legal framework need to resolve to provide a sustainable footing for the facility?
Yeah. Well, again, that's a hypothetical question. It's not for me. We're at the stage where the facility's only been running for a few months, and it is a pilot, and it's novel approach, and it's an approach, as I understand it, that comes from an extremely good place. But all I can say is that the prosecution policy is not a replacement for a full legal framework. And in terms of criminality, there are Lord Advocate's guidelines in relation to the reporting of offences detected within the facility, which are provided to the police. And where the police detect possession of offence and seize a suspected controlled substance, they submit it to the Procurator Fiscal. They do so by an abbreviated report. And if there's any other offending, including other Section 5.2 possession offences detected out with the facility, they're dealt with in the normal way. The law applies. So if there's to be a full legal framework that impacts on the operation of the facility itself, then that's a matter for parliamentarians to develop. It's not for me, but it might usefully be informed by the experiences of those who are operating the facility during the pilot period. I think you're already hearing about challenges in and around methods of assistance, provision of inhalation spaces, applications of tourniquets and the like. But that's not covered by this statement of prosecution policy.
Okay, thank you very much, Lord Advocate. That is the end of our questions. Thank you, Ms Hamilton. We're very grateful to you for coming along this morning and for giving us your time and your evidence, and we will reflect upon it as we go forward with the rest of our evidence sessions. Thank you very much.
Thank you.
Order, order. Good morning. We're now resuming this session looking at safer drug consumption rooms, specifically the Fiscal in Glasgow. And we welcome Superintendent Joanne McEwan from Police Scotland, who's here to give us evidence this morning too. So good morning, Superintendent. Thank you very much for being here. Could I ask you, in opening, to characterise how Police Scotland's approach to the policing of the Thistle Centre?
Yeah, of course, and thank you for having me this morning. What I'll do, if it's helpful, is just give an overview of really the two main aspects, so how we would deal with incidents reported within the centre and how we would deal with incidents reported outside. So, excuse me while I refer to my notes. So, as the Lord Advocate has explained this morning, there's no change to the law, and possession of drugs within the facility remains a criminal offence, and we've been very clear on that throughout. But of course, the statement of prosecution policy clearly states it wouldn't be in the public interest to prosecute users of the facility for a simple possession offence. A couple of points that I would like to highlight just before I go into a little bit more detail about how we deal with incidents is that attendance at the facility, so persons on their way or attending the facility, can't use that attendance as an offence, as a defence, apologies. There's no tolerance zone, as I know the Lord Advocate explained this morning, and that the statement relates to the footprint. And we've been very clear in developing the guidance alongside the proposers to clarify exactly what the footprint of the facility means. Again, another important point, and apologies, there might be some repetition this morning, that notwithstanding the statement of prosecution policy, all decisions made in terms of prosecution are for Crown and is not a matter for Police Scotland. So our role is to report matters to COPFS in that regard, and that's been the cornerstone of the guidance that we've developed. So I'll start with possession-only offences, and that's the Section 5.2 Misuse of Drugs Act. So recorded police warnings, they're not used for users of the facility found in possession of drugs. So we will not use a recorded police warning, which can often be described as a direct measure. Where offers detect an offence and seize a suspected controlled substance, they will submit a report to the Procurator Fiscal. And it's a particular type of report where we will be seeking advice and guidance. So we'll be seeking advice and guidance from COPFS in terms of how they would like us to proceed, and that's where they make that prosecutorial decision. This applies only for a simple Section 5.2 offence where there is no other offending. And it's obviously clear and important that when we're submitting that report, that the connection to the safer drug consumption facility will be made clear in the report. So I'll move on now to talk about other types of offences. I'll start with possession offences outside the footprint of the facility. So they will be reported as normal, as they ever would be. That could be by a recorded police warning, or it could be a standard prosecution report, and that will be a decision for the officer based on the prevailing circumstances. Moving back into the footprint, should we attend an incident where there are a number of offences, so perhaps a broader offence, for example, a theft or threatening behaviour, for example, and in the course of dealing with that incident, officers also detect a suspected controlled substance, so a Section 5.2 offence, all matters would be reported together via standard prosecution report to the Procurator Fiscal, and again making very clear through the case reporting mechanism that these incidents relate to the safer drug consumption facility. What that allows our colleagues in Crown to do is apply the statement of prosecution policy as they see fit to the Section 5.2 offence contained within that broader number of offences. Any offences detected within the facility where there is no possession offence, there's no Section 5.2 offence, they will be reported and dealt with in the normal manner. The reporting mechanisms, as I touched on earlier, as we've worked through the guidance, have been set up in such a way to ensure that we can call out very clearly to colleagues in Crown that any incident, whether it's a simple possession offence or a broader offence, has got that connection to the SDCF. In addition, we provide a report on a weekly basis to colleagues at Crown so that they can be very clear as to whether or not there have been any incidents for them to report. And as I said earlier, in any cases that are covered by the statement of prosecution policy, we will seek advice and guidance from Crown as to any further action required from police. I think it's really important to say, as I sit here and speak to you today, there have been no crimes, there have been no incidents. We do provide a weekly report, but it is a nil return thus far.
That's helpful. No, I just wonder if it's a particular challenge for officers who police in that area to understand that this is a slightly different scenario from the one they might face in another part of the city. Is that something you've had to be aware of, or you've had to brief officers specifically around?
We certainly have briefed officers specifically. I think it's important to say, and we probably all acknowledge, that it's a novel approach, first time in the UK. And so for that reason, for myself and my team, and we work primarily in strategic policy and harm prevention, I'm not in local policing at the moment, but have worked very closely with them throughout the development of the guidance. And what's been important for me and my team
I have no idea what that is, but I think it might have something to do with
that could go on for some time. We might have to carry on.
So I think we might just try to ignore it if we can. It's maybe asking a bit much, but
Should we shut the windows, Chair?
That would help, thank you. I think it'll take up one of them. Yeah.
Needs some kind of balance.
I'm going to suspend the meeting just for a couple of minutes just to see if we can get some way around this. And sorry to have interrupted you, Superintendent McEwan. These are things we can't, unfortunately, do very much about. But I think you were explaining to us about the challenges of policing in the area.
Yes, and as I was saying, it's been really important for myself and my team to give officers the clarity that they need to really understand what we're asking them to do, but also what we're asking them not to do as it pertains to the guidance. So in order to do that, we've worked very closely with colleagues in G Division, where the Hunter Street facility is based. We've had a very robust governance structure that has been in place over around the last 18 months, and we've also carried out robust testing and exercising, and we started that with local officers, so frontline sergeants, constables who will be policing that area, and had what we refer to as tabletop exercise at that level. We then took that internally to police-only wider tabletop exercising, and that included, for example, colleagues in CGSD, our Criminal Justice Department, colleagues in C3, our Contact Command and Control, colleagues in crime, in terms of crime management, and we did that at that level. And then we took that testing one stage further into a multi-agency context where we had partners involved as well. At each level, local officers being able to influence not necessarily the approach, but the clarity with how we explained what we were asking of them. And SMART too were very helpful in terms of leading those tabletop exercises for us. And that helped us because I think when you work in a space, it can be very clear to you, but may not be clear to other people. So I'm confident, and the feedback certainly that I have from local officers is that there is a clear understanding of the guidance.
It's good to know. Thank you very much. I'll pass now to my colleague Maureen Burke.
Thank you, and thank you for coming along today. I think a lot of what I was going to ask has been covered in what you were speaking about there. But one of the questions I was going to ask is about the local people in the area. Have you had many complaints from them about maybe what issues, if any, have been happening there? I know that also I was going to ask about the impact it's got on the level of resources that you've got. Is that enough? So I think everything else I was going to ask has actually been covered.
In terms of local people, we, at a point in time in the stages of the implementation, so towards the end, supported partners in Glasgow Health and Social Care Partnership in their community engagement, because there were questions for police, questions around how we would continue to police a local area, and we felt it was important for us to go along and support that so that people could get those messages straight and direct from us. Local officers, and particularly community officers, continue to engage with community. You'll know that that's a central part of the policing model in Scotland. And what's good about that is that it allows us to meet community needs, whatever they may be, in the area around the Thistle or elsewhere. Before I came, as you would expect, in preparation for today, spoke with the leadership in the division to understand whether there were any ongoing concerns. There aren't, that they're aware of, but it's important that we remain engaged and remain open. The Lord Advocate spoke earlier this morning about the evaluation. That's important, and that we will contribute to that evaluation so that it can be robust and helpful.
That's really good. Thanks for that, because I know it was quite problematic at the start to get community engagement, but it's good to know that that's still going on. So thank you very much for that.
Thank you.
Christine Sullivan.
Thank you very much for coming along today. I think you've already touched upon this in your previous answer. Do you have any concerns regarding the policing of the Thistle and the surrounding community? Are there any issues that you feel haven't really been addressed as yet, or any issues that have arisen that haven't perhaps been anticipated?
It's a good question, because when you're dealing with something that is new and different, and you try to I guess anticipate every potential scenario, and that was part of the testing and exercising, and that was important so that we could be confident that the guidance we were giving to officers was helpful to them, but not only to them, to the proposers and to the wider community, so that everybody had a clear understanding of our approach. No, thus far I'm not conscious of any challenges. There's nothing that we found to be insurmountable in terms of the guidance and in terms of the approach. The statement of prosecution policy that the Lord Advocate set out is very clear and limited, as she mentioned this morning. And for me and for colleagues in policing, that's been helpful because it allows us to have an approach that is specific, limited and very clear for officers.
Okay, so without an exclusion zone, what is to stop officers from identifying and intercepting regular visitors of the Thistle who they know are likely to be in possession of a controlled substance?
Essentially, reasonable grounds is what would prevent that. So somebody on their way to the facility, that on its own would not offer an officer reasonable grounds to stop and search that person. That's been another important message for officers in terms of the guidance. Whilst it wouldn't offer on its own reasonable grounds, nor would it offer a defence to somebody who was found in the possession of drugs on their way to the facility. So if I can make that important distinction, if an officer did have reasonable grounds to search somebody and found them to be in possession of a suspected controlled drug, somebody's assertion that they were going to the facility would not provide a defence, and the officer would deal with it in the same way. But to your specific question, no, there would be no reasonable grounds on that basis alone. And I think, again, a further important message, not just for officers, but for the wider community and, of course, people who will use the service, is that it's not the intention or the aim of Police Scotland to target people who are using the facility. That would not be, in my view, in the public interest. It wouldn't be in our broader approach to drug-related deaths and harms. But we will, of course, continue to operate within the law and the Misuse of Drugs Act as it's set out.
Thank you.
Thanks.
Jack Rankin.
Thank you, Madam Chairman, and thank you, Superintendent, for coming here today. Can I ask how you would respond to concerns that, without a full legal framework, there may not be an equal and consistent application of policing?
I'm not sure I understand the question.
Well, it seems to me that the Advocate General in her prosecution advice has carved out a very specific exemption in this instance. That some people would certainly have the perception that that means that the law is being applied differently in different areas of Scotland. They would have that perception, at least.
Okay.
Even if you might say that that's not the case, not your point of view.
We wouldn't offer a view in terms of the legal framework or this statement as made by the Lord Advocate. Our role is to operate within that framework as it exists. And as I said earlier, the guidance that's been provided to us is very clear, provides us with a clarity of understanding what has been asked of Police Scotland and allows us to police the facility and the wider area in a way that is clear for both us and the wider community. So no, we wouldn't offer a view necessarily on that aspect.
Can I just follow up on that clarity point? You're very clear that you consider it very clear, but within the force, have any officers expressed any uncertainty on how to police that area, or do you think that that's shared by all of your colleagues, that view?
I'm confident that it's shared by colleagues. Important to say that it's focused in a specific area.
Yeah, of course.
And so, again, that has been helpful because it means that we've been able to do very focused engagement with officers in that area. However, the guidance is national guidance. You'll be familiar, a single service, and we do have the ability to move and deploy officers all over the country. So it's also been important that that guidance is shared more widely for broader awareness. But no, I've got every confidence that officers in the local area certainly understand and are clear as to what is being asked of them. But in policing, I guess a core part of it is that officers who do have any need for support or guidance have that available to them in a number of different ways. So, for example, through oversight from Contact Command and Control, who have been very much part of the development of the guidance, and also their first and second or senior line managers who can also provide dynamic guidance to them. So there's a number of guardrails, I would say, but I've got every confidence that officers are clear.
Thank you, Superintendent. Thank you, Chair.
Thanks. Lynn Stewart.
I think my question was actually answered at the beginning. It was a bit unrelated to incidents that would happen in the Thistle and how you would deal with that. But can I just ask, because that has been answered, do you see like the police officers building relationships within the community with the staff within the facility and obviously with the users that are maybe getting in and out, and then they can identify like good relationships?
As I mentioned earlier, Police Scotland has a community policing approach, and that's always been the sense. Initiatives like this, I think the important part to recognise, and you've kind of set out there, is that we've got an important role to have good relationships with the people who work at the facility, the wider community and people who use the facility. And there's a great benefit to that because it allows us to meet local people and police the local area in a way that meets their needs. My experience throughout being involved and engaging with partners and colleagues in G Division is that there has been a real benefit actually to this process. It's been a significant multi-agency process of engagement and working closely together to support the delivery of the pilot. And I know from speaking to colleagues in G Division that the engagement they then had with the local community allowed the local community to voice their opinions about the safer drug consumption facility, but also other things in the area that were challenging for them. So I think to your overall point, it has been a benefit and a helpful exercise in that regard.
Thank you. Superintendent McEwan, you mentioned that the data you collect as Police Scotland about incidents or activity around the vicinity of the Thistle would feed into the evaluation, if I understood you correctly. One of the UK drugs charities release has suggested that it's important that that data is recorded but also made publicly available. Will that information that you're collecting be shared publicly, or will it just feed into the evaluation?
It really depends on the type of data that is being discussed. A great deal of the data that we record in any event goes into the public domain. I would use stop and search as an example of that. The stop and search data that we record right across the country is reported on publicly and is publicly available through dashboards. So there's a great deal of data available already. Specifically in terms of the evaluation, we're represented on the subgroup and will be able to support the evaluation with whatever data they feel is relevant and that we can indeed provide. I wouldn't be able to answer that question directly without understanding exactly what data, but broadly, in broad terms, I think it would be likely that we would be able to offer that.
That's great. Thank you very much. That concludes our questioning this morning. So thank you very much for coming along. Sincere apologies for the disruption, which seems to have ended just as we have. But thank you very much for putting up with that and for answering the questions so directly. Thank you.
Thank you.
Thank you.